do have the question very similar. I mean, and you know, he admitted
All right, welcome back. I feel these one-day-a-week classes, I feel very distant. I don't have the same kind of connection I do usually 2-day weeks. It's a little weird for me. But thank you for indulging my cancellation last week. It was a good trip. Went to Richmond. They had arguments in the emoluments clause litigation. The judge mentioned a brief a couple times, which is always good. So it was worth the travel, kind of. The attendance is running. Please check in if you can on your apps. A friend of mine is a lawyer in town, Mark Bennett's a criminal lawyer. He does a lot of First Amendment litigation. He actually challenged several of the Texas revenge porn laws. He's looking to hire someone for the summer, maybe for the fall. So if you're interested, send me your resume and I will pass it on to Mark. But he's looking for someone specifically to do First Amendment work on a part-time basis. So he's a fantastic lawyer. He's had some really good cases, and I encourage you to drop me a line. Okay. Several of you asked me about the executive order that was signed by the president. Oh gosh, about 2 weeks ago now, 1 week. I can't even keep track of when it is. Was a week ago? Yeah. The upshot of it is that not much. There were various rumors suggesting that schools that failed to protect free speech on campus would lose funding. That may yet happen, but the actual order itself doesn't direct the withholding of funds. I'm going to paraphrase. All the order says is that if you are a public university, you must abide by the First Amendment. Well, you gotta do that anyway. And if you're a private university, you have to abide by your own codes of conduct, which actually is a good idea. If you have a stated policy, you should abide by it. And because this is a spending clause issue, the schools, of course, are welcome to decline the money. And they can just say, we don't want it. Well, that's not likely to happen. So I don't see any immediate consequences from the executive order. It may even potentially backfire, and I'll just give a brief explanation why. Many of you saw the protest video from me from last year at CUNY, New York. I have free speech rights, and the protesters can also assert free speech rights. So I suspect some schools will do say, aha, this means you have to protect the rights of the protesters, so they can go protest and disrupt events. So, you know, unintended consequences always. So I don't think there's going to be much dealing with this executive order, but you know, we'll see what happens. Okay. Yeah, Carlo.
What about the rights of attendees who want to hear the message?
Okay, so I am actually writing an article on the exact question now about the heckler's veto. I think you have to look at campus protests on a few different levels, right? There are a lot of levels. So first, there's the right of the students that invited a speaker to hear, right? We say the First Amendment is the right to listen. Second, there's the right of the invited speaker to speak. Third, I think there's the right of the protesters to be heard. And number four, there's the right of the student body who did invite the guy who still want to learn more to disrupt the educational environment. So you have to look at this from various perspectives. It's not only my right as a speaker, it's also the right of the people who invited me to hear and people who were just walking down the hallway want to listen. And I do think that the students who protest also have free speech rights. You can't forget about them. There was an incident at Portland State in Oregon about 2 weeks ago where a guy was supposed to give a speech, and then a protester got up and he had a cowbell. He was standing right in front of him. He was ringing the cowbell for like an hour straight. I don't know, I won't get tired, but he was banging this cowbell for an hour straight, and the police in the room did nothing to stop it. Problems there. Okay. Any other questions on your mind? I, for one, am grateful that I don't have to write about presidential subpoenas and presidential indictments. I'm grateful we can just move on. I was dreading it because it would ruin my summer. But I can write about other things I care about. All right. If you haven't signed in for the attendance, please do sign in. I think most of you have. Okay. All right. Any other questions before we get started? Okay, so last class, which felt like ages ago, we discussed the freedom of speech. This new topic is broadly labeled freedom of association, right? Freedom of association, which is something of an odd label. Because if you read the First Amendment, and we always should, it says nothing about a freedom of association. It says that the government can't make any laws respecting or abridging the right of the people to peaceably assemble, right? What does that mean? If we want to go to protest outside City Hall or protest outside the White House, we should be able to, generally. Lots of limits on the assembly. But the right of association isn't really based on the First Amendment by itself. It's sort of, dare I say, in the penumbras of the First Amendment. Indeed, Justice Brennan, who wrote the first, or I guess the first and the third case, he wrote Alabama and Jaycees, directly builds this right of association on some sort of right of intimate privacy. Griswold, which was the case about whether a married couple can access contraception. And in other words, this isn't really a First Amendment doctrine. And I always feel funny teaching these cases because they have nothing to do with the First Amendment. Janus kind of does. Dale a little bit more. But Alabama and Jaycees is almost not First Amendment in any regard. But it is First Amendment in this important regard. When people choose to speak individually, there's only one person, right? Guy burning a flag, guy burning a draft card. But when people choose to convey a message collectively, it's a different type, right? I can express my message just by myself, or I can join a group of people who want to pool together resources and convey a message of a broader scope. If the government restricts my own personal speech, it's an easy First Amendment question. If the government restricts the ability of this collective to speak, it then becomes more of this right of association. And you can think of it in terms of the Citizens United question, right? If I pay for a movie by myself, it's fine. But if a corporation pays for a movie to criticize Clinton, well, then that goes to this entire First Amendment analysis. So these aren't purely free speech cases, but lurking in the background is always the ability of these groups to speak freely. All right? And if you've been trying to keep track of the different levels of scrutiny in the First Amendment, just throw that out the window for today. I don't know what the hell it is, right? I read Brennan and I become very angry, not because I disagree, because I can't teach it. It's just very hard for me to teach a Brennan opinion. Because he puts in all this language that's just gibberish because he hopes other people will just run with it and make other stuff up. And there's no structure. There's nothing here. So I'm grateful there are not many more Brennan opinions I have to teach this semester. Okay, let's start with the NAACP case. I'll give a little bit of background. We studied, or if you haven't for con law, you have studied the aftermath of Brown. Right, Brown v. Board was decided in 1954. That case involved public schools in Kansas, South Carolina, Virginia, and Delaware, and also D.C. That case did not purport to integrate schools nationwide. It didn't even pretend to. You had a follow-up case called Brown No. 2. And Brown No. 2 said, okay, you states, you try it again, and you guys integrate with all deliberate speed, right? And then these lower court judges would start to monitor and supervise school districts one at a time who fought, kicked, screamed, and did not want to integrate their schools. But integration was only one part of the so-called massive resistance, right? There's only one aspect of the battle. These groups emerged called the Citizens Council, these white citizens councils. And they sought to use all lawful means, and they were actually pretty careful in some regards. They want to use all lawful means to resist integration by the courts. And one of the ways they wanted to resist integration was through the use of boycotts, right? that if they found that you were admitting black patrons to your store, they would boycott you. And then in turn, civil rights groups started boycotting the other businesses, so the boycotts went back and forth. But one of the ways that they were able to boycott was by trying to obtain membership lists. All right? That if this group was able to obtain the membership roster of all the NAACP members in Alabama, they would then know who to target with boycotts and perhaps even violence. All right? That if we know who you are, you're supporting an unpopular cause in this state, that you can be targeted for private violence. Maybe the Klan will show up at your door. Right? Why are you helping these people? So this was not a trivial concern. Also, this was not a case where the Alabama government said, we want to force this group to provide this information because we don't like them. It arose in a fairly unique context, which I think is important to stress, where a government was employing a neutral law, right? It wasn't targeting just them, maybe they were, but on its face, they weren't targeting this one group. But the consequence of revealing the membership of this one group is that it could be leaked out to the public, resulting in boycotts, intimidation, threats, etc. Okay, I have no idea where I am. Does anyone remember? You? Good memory. Oh my goodness. Okay. So is Marissa next or Costa? Okay, good. Okay, so Christine, you want to go first, please, and just give me the facts in NAACP versus Alabama, in 1958. I'm sorry, it wasn't Brennan, it was Harlan, but still, I don't like it. Same difference.
Attorney General of Alabama filed an equity suit to basically stop the NAACP from continuing.
Okay, now why did they try and shut down this group? What were they doing that was wrong? It's actually, technical, but they were doing something wrong. What was the basis of this litigation? It's a corporation question for those taking corporations. Yeah, Brittany.
That they were required to file membership via corporate charter.
Yeah. So this is the law of corporations, right? If you're an out-of-state corporation, I think the NAACP was maybe based in Baltimore or New York, I can't recall, but they were based somewhere out of state. And if you're a corporation and you want to do business in another state, you're required to file paperwork with the local corporation commission, whatever they call it in the state. Sometimes this paperwork is onerous. You might have to register. You might have to disclose your officers. You might have to disclose certain financial information. These are laws that apply to everyone, but let's just be blunt here, right? Do you think the Alabama government went after every single corporation that failed to register a charter in their state? Of course not. Don't even for a second think that was the case. But look, on paper, we're just enforcing our neutral, generally applicable corporation laws. But come on, give me a break, right? They're going to waste the resources out of this business. So Costa, the NAACP didn't put their paperwork in with Alabama. What did Alabama do in response?
Alabama basically puts them in civil.
Well, why are they put in civil contempt? What did the group fail to do?
They wouldn't disclose the names and addresses of all the NAACP Alabama members.
Okay, good. So first the Alabama Attorney General sought an injunction. He wanted to block the group from operating in the state. And again, I am confident that he didn't do this for any other group. He did this only for the NAACP. I'm pretty confident in that. Then he sought discovery, right? Civil litigation, you get discovery. He sought to produce papers, including the names and address of all members and agents, not just the officers or employees of the company, right? If he'd only asked for the names of the officers and employees, I think it would have been a very different case. Because if you are an officer of a company and you're operating illegally in the state, you're at risk of prosecution, right? You are basically acting illegally. If any of you want to be a corporate officer and you fail to do the right paperwork, you're breaking the law. I think we can all agree on that much. But they went another step, And they request the names of the members, the rank and file members, who, as far as we know, all they do is they paid a membership due, right? They put in a check. Maybe they attended a meeting, right? And this is going on around the same time as the Red Scare, where everyone's being accused of being a communist and say, oh, you have a list of the names. So this was a huge issue of producing lists of names of people that then could be targeted for harassment by private actors. So the NAACP refused to comply with the court order, and then they issued a civil contempt order, which is a fine, basically put out of business. The case is then appealed to the Supreme Court. So Carlo, what is the NAACP's argument about why this compelled disclosure of their memberships is a violation of the Constitution?
Because it would discourage would-be members from joining out of fear of economic reprisals or like employment, losing jobs or being denied.
Okay, so yeah, so correct. So Carlo, I think, is right. The group argued that were this information disclosed, it would punish their members, it would create economic repercussions, it might discourage people from signing up in the future if their names were revealed, and let's just be blunt here, violence, right? These people might have physical violence brought to their doorstep if their home address is revealed. Okay? Now, Gabe, why is that unconstitutional, though? I think we all agree that those are very bad policies, those are very bad outcomes, but why is it unconstitutional? What's the constitutional argument?
For them not to do that info?
Yeah, I mean, in other words, in order to say that the state contempt prosecution is unlawful, there has to be a federal constitutional issue. What exactly, and let's try and be as precise as we can here, what exactly is a federal constitutional issue at play?
Living immunity and privacy.
Okay, let's talk about privacy for a minute. Why? Okay, let's talk about privacy for a minute, Gabe, right? We learned last semester, or whenever it was, Griswold, right? The right of a married couple, they have privacy in their bedroom, they can engage in intimate relations, and have contraception. Gabe, here, this is not in a bedroom. These are people who are soliciting membership in a public organization where basically anyone can join. How is this privacy? Right? How does this fit into the privacy frame?
Because the joint organization is voluntary, and if the info is exposed, then I guess that precludes.
No, you're right. If it's disclosed, bad stuff happens. I think we all agree. My point's more specific, David. Let's try this. How is this privacy? In other words, how does compelling membership relate to, like, a husband and wife in bed? Like, where's the linkage there?
Isn't it in like their right to be in a group associated with other people and not have that information spread around?
Yeah, but why is that a right? Evan, you jump in.
Liberty.
Liberty, yeah, thank you. But what's the liberty, Brittany? Why? Why is this a violation of privacy? Why is this a violation of Griswold? Why is this? Why? What is the basis of this ruling? I read it every time. I still don't know the answer. But what's the basis of this ruling?
Well, because Alabama has no interest in compelled disclosure.
Sure they do. If people are acting illegally in the state should know about it. That's.
They did it under the header of a corporate compliance, and all they needed was officers.
Well, maybe they want to know people who give dues to get refunds.
But it doesn't affect due process if you're...
Due process procedure? They got a trial. They had a judge.
No, but it's liberty through
Okay, liberty. Okay, so this goes back to Evan, right? John?
I was to say, isn't it the right for them to just be able to exclude information from you if it's not required from everybody else, and they have the right to exclude it?
Well, it is required. Everyone has to disclose this
Yeah, but
information.
we have the right to exclude the state from our bedroom. So don't we have the
But that's because it was a private bedroom. My point is, this is not a private bedroom. This is a public organization that basically anyone can join. Pay dues, you're in. Roxy?
like the privacy to in your beliefs, to
Privacy in your beliefs. So So if people share beliefs, then they're then excluded from general corporation laws? But, disclosing donors and stuff?
Well, their association together, like the right to like associate and talk about these things privately without including the state.
Andrew?
I was saying the constitutional issue here is that it effectively restrains your freedom of association.
Okay, but why is that a freedom? Why is association a freedom? That's not in the Constitution. Now we're getting somewhere. Why is association a constitutional right?
Because we've read it in as almost like an honorary First Amendment right.
Honorary. Oh, I like that. An honorary First Amendment. Yeah, like a participation prize, right? Like second. Joyce, why is this something that the Constitution protects? Association. I think we're getting closer now. Why? I mean, where does this come from?
It's protecting like their individual beliefs.
So is your point, let me just drill on this a bit. So your point is, even though people are joining a group, it still is based on what they believe individually, so that's like a First Amendment, like free speech personal issue?
But if they're joining a group, don't they have like some similar beliefs that all of them kind of, well, I don't know.
Yeah, it's hard. Di, I think your hand was up?
No, I don't understand why it's privacy. I mean, it's the group that you're joining is a political group, and it's using you're trying to speak a message. So I've always thought it was just that this was the chilling effect on the speech of the group in general. It's like if the association doesn't do you any good, your personal speech as an individual is a lot less powerful than it is in a group. So for political purposes, the right to be able to join as a group and speak is what I think is trying to be preserved in the First Amendment.
What?
I think it's not that the government doesn't have an interest in this law, and even if they misuse it for nefarious purposes, it's still an interest, but it's balanced against the interest of the association to protect its members, which is founded on like a policy concern, like you were saying, of forwarding speech and making sure that it's protected.
Yeah. Yeah, Alicia.
It says the vital relationship between freedom to associate and the privacy in one's associations. So it's your beliefs, your internal beliefs are private.
Right.
And your
So privacy refers to your own beliefs, but how does putting your name on a membership list affect your beliefs? It's roundabout, right? We're only talking about disclosing the membership, not making you take or not take a position.
because you're less likely to subscribe to a membership.
Agreed. That's a good policy argument. I'm trying to drill down. Carlo?
Well, if it was just the individual speaking, then I would think that there's more protection that's needed for the individual speech, but because they're joining an organization which is more powerful to get that speech out, then maybe it's a little bit less scrutiny, but that's why you're going to have to weigh the interests of the state as to why they're trying to themselves.
So, yes, let me just pause for a minute. I didn't assign the cases that come after this one. There were a case I called Buckley, which you read part of, and the McConnell case. And these decisions involve whether you can make someone disclose money they contribute to political causes or campaigns. And I think Justice Thomas discusses in Citizens United, right? Thomas found that the disclosure laws in Citizens United were unconstitutional. He said that people who give to various political campaigns might be retaliated against, and there might be threats. A similar argument here. And the court said, no, in order to reduce the risk of corruption, we have to know who's giving money above a certain threshold. So maybe the argument is that, I think some of you are circling around this, the state's interest in just going after rank and file members is not enough, but maybe if a donor who gives $5,000, $10,000, whatever the cutoff might be, then maybe you could force compulsion, right? That the state really doesn't need to know about these rank and file members who paid a $5 due. I don't know. I'm not mad at you. I don't think Justice Harlan's opinion has any particularly good holding of why this is protected by the Constitution. I think this case is sort of Griswoldy, right? Penumbra-ish in how it was reasoning. And this is a very, this was a time when common law was in flux. And Justice Harlan, you might recall, in Griswold said that we don't need penumbras, we just need the 14th Amendment. And that's some certain types of liberty interests. So that might, it just may not be the 14th Amendment and nothing more. But I don't exactly know what the basis of the opinion is. It's pretty thin. Cameron?
To me, I almost took it while reading this case, that it was almost just an eye test case.
A what?
Just an eye test.
An eye test. What do you mean an eye test?
Like, you can tell us whatever legal, the reason that.
We know why
works,
you're doing this.
So we know exactly what the deal is here.
Yeah. I think Cameron's on to something, right? We all know Alabama was trying to shut down this civil rights group. And the court said, okay, that's what they're doing. Let's do stuff to make that not happen. And it didn't really matter. Maybe that is that the answer? I don't know. Maybe.
That's just kind of.
It doesn't matter. In other words, because if Alabama got away with this, then all the other states would have followed suit, and they would have shut down these civil rights groups in all these states and gotten their membership rosters, which would have made it impossible for these groups to function. Right? Even think of the New York Times versus Sullivan case, right? Heed their rising voices, right? They were raising funds for MLK. And they wanted you to put your name in the bottom corner and send in a check to this group. If people knew that their name, what they put in the corner, would be sent to the government, they wouldn't write those checks. So I think maybe your explanation is as good as any. So the holding then, if we can call it that, right? The holding then is that, I'm just going to read it. Alabama has fallen short of showing a controlling justification for the deterrent effect on the free enjoyment of the right to associate, which disclosure of a membership list is likely to have. So in other words, they don't have a good enough reason to disclose this. They can probably go after the officers, maybe the employees, but not the members. I think the state probably does have an interest, right? If I pay membership dues to a corporation that's acting illegally, then the state should be able to return those dues. I mean, again, this is not what happened here, but as a general matter, if I'm paying dues to a group that's acting legally, as a consumer protection matter, I would want my dues back. And the membership roster will facilitate the return of dues. So there's a perfectly legitimate reason, but that's not the real reason why they were getting the names of the members. Because you know the second they got that list, they would hand it over to someone and they would run with it. All right, so any other questions on Alabama? And by the way, New York Times versus Sullivan was also an Alabama case, so we're having a little bit Alabama heavy. Okay. All right, so let's move on to the next topic, right? The first topic was about compelling disclosure, right? Forcing this civil rights group to disclose who were among their ranks. The next case, Janus, concerns a different issue. It's whether people who work for the government can be compelled to what? Well, we all agree that these government employees or these employees of unions who are being forced to pay money by government, by state law, they have to pay money. Right? They have to pay money. And that money is going for different purposes. Some of the money is going to support the union, which engages in what's called collective bargaining, which is basically negotiation. Some of the money might be going for training purposes. And some of the money might be going for political advocacy. Now, the guy in this group, the plaintiff in this case, a guy named Mark Janus, he worked for a union, and under state law, he was required to pay certain amounts of his paycheck to this union. And he didn't agree with a lot of the positions that the union was taking. Yeah?
I didn't think he was a union member. I thought he was a non-union.
I'm sorry, but the state law required him to.
Or the non-union member.
Yeah. Just to be very precise here, right? The government can't force you to actually join the union, but the laws can force you to withdraw from your paycheck amount going to the union. Okay, make sure I said that right. Yeah, he didn't actually join it, but he was subsidizing it by his paycheck. Thank you for correcting me, Dyer. And he said, wait a minute, I don't want to spend this money on the union. I don't agree with their perspectives, right? They are taking positions that I disagree with. And I don't want to deal with this. Okay. So JC, let's walk through this case, right? What are the types of fees that Abood, this case from the 70s, Abood, what were the types of fees that Abood permitted to be withdrawn from a salary?
It wasn't a full-blown membership fee.
Good. What's that word?
It was an agency
Bingo.
fee.
Yeah, okay. What are the agency fees?
Basically, it meant that even if you're not a member, like you still pay money for the things that the union does on behalf of, I guess, the employees of that sector.
Okay, yeah. So have you guys taken any classes in labor law? Yeah? No? All right, so what is a union? Has anyone ever been a member of a union? Which one?
Screen Actors Guild.
The Screen Actors Guild. Wow. What were you doing?
I was doing a commercial.
Okay, very cool. How do unions work, right? Under federal law, unions are basically given to negotiate, right? If a single union is authorized, then the employer is obligated to negotiate with one union and only one union. And they negotiate for wages, for training, for benefits, a whole host of different things. Now, what happens if there's a firm with a union, and then let's just say Josh doesn't want to join the union? Well, he will get all the benefits in the form of higher wages, training, etc., but he's not paying the dues. So a number of states enacted laws which require public sector workers to become members of the union and pay certain dues. That was the original design. Okay? Now, if a private corporation, requires its employees to be union members, there's no First Amendment issue, right? But if a government law requires you to become a member, there's a problem. So we have this case called Abood. And Abood said, well, you can't really make someone become a member of the union, and you can't make people subsidize certain types of political speech, but you can still make them pay something, these agency fees, right? These are the fees that everyone benefits from, and it would be problematic if no one paid them, because then you free ride, right? I'm getting the benefits of the union, but I'm not paying for their negotiation. So Abood struck this compromise, right? They can't be made to pay regular dues, but they can pay these agency fees, these shop fees, right? Okay. That ruling became very, very unpopular. And this is not in the case, but I'll give you the background. Republican politics hated these sorts of arrangements. And a number of states, Texas among others, basically abolished these sorts of mandatory due structures, right? Texas is a right-to-work state, it's what it's called. They don't have a regime where you're required to pay these dues. Other states are very pro-union, Illinois among them. So there was a very long campaign to try to chip away at these compelled dues. Why? Republicans viewed these as basically fundraisers for Democrats in many elections. That's the politics there. It came to the Supreme Court. Be real for a minute, right? It came to the Supreme Court. There were several cases decided, one of which is called Harris versus Quinn, decided in 2014. And this case basically signaled, okay, you guys were ready to overrule Abood. Okay? Then, in 2015, the Supreme Court granted certiorari in a case called Friedrichs versus California. It was a case from California, duh. The case was argued, and it looked from my vantage point, at least, that there were 5 votes to overrule Abood. Then Justice Scalia died. A lot of things happened that year, yeah. So the case split 4-4. And I put this quote in the book quite deliberately. Justice Ginsburg said, She praised the divided ruling. This court couldn't have done any better. At the time, she thought Hillary Clinton would appoint the next justice, so Abood was safe, not so much. So shortly after Justice Gorsuch was on the court decided Janus, and it went 5-4 to overrule Abood. I was actually in the court the day this case was decided. Let me tell you, Kagan was livid. You can tell this from her opinion, right? But she was pissed. She was not happy. And she described, which was the 6-year crusade by her black-robed rulers. My goodness, what good alliteration. Her black-robed rulers. She's a good writer, especially when she's angry. The case largely turned on stare decisis. But I just want to focus on the free speech issue for a minute. Kelly, why does making someone pay money, dues, fees, whatever you call them, violate free speech? I mean, what's the argument there? Why does paying money violate free speech?
It's like you vote with your dollar, what you put money into or clothing.
Okay, I think that makes sense. So if you know your local union's only funding Democrat politicians and you don't agree with them, then are you being compelled to speak? In other words, is the government making you hold up a button saying vote for Smith? Hold up a sign saying vote for Smith?
No, you're associated with those that are doing it.
Do you have to go to a rally and stand next to candidate Smith?
No.
No. So Ryan, let me ask you another question, a little bit different tact. We all pay taxes, right? Taxes go to things that we do not agree with. Can I go to court and say, you know what? I object. I am not going to pay federal income tax anymore because I disagree with the federal government. It shouldn't exist. Just burn it all down. Or I go to Houston City Council. You know what? I don't like spending my tax money. I'm going to withhold my paycheck.
No, you can't do that.
Well, but what's the difference between what Kelly said? I mean, you're subsidizing speech you disagree with, associating with a cause you don't like.
I think taxes serve a more compelling interest just due to kind of the general.
Well, I mean, taxes are important, but also in this case, Illinois determined that the unions are important. If you don't have these fees, the unions will fall apart. By the way, it hasn't happened. All the dire predictions the unions will fall apart were all bogus. It's all BS. They're doing just they just found other ways to take the money. The states can adopt to this very quickly. All things. Oh, this is the end of the world. Like 8 months ago. Yeah. Yeah. I'll give you an example. One of my friends proposed this one. The state law says now you have to pay dues of X dollars to the union. Okay. You pay a tax of X dollars, which we then give to the union. This can be worked around so easily. It's such an easy workaround. But that goes back to the point of taxes, right? If the government can just tax you and then give that money to the union, can you challenge the tax, Ryan?
I mean, I suppose you could, but I don't know how far you would get with that.
Kelly?
Does that have to do with the benefit you receive in return?
Well, we all receive benefits. The garbage picks up, garbage pickup, potholes are
So
fixed.
that's why you can't do it with the tax, but with the union.
But you're getting benefits. They're negotiating for higher wages for you. You are getting benefits, better health care, whatever. John?
Yeah, but that tax, if it was a tax, applies only to a very specific group of people, whereas everybody pays income tax.
Well, here, this applies to all
And
public
you
sector
get to
workers
talk
in the
about
state.
You don't get to protest in court, but I get to protest with my vote and say I don't like that incumbent, I want a new incumbent. But with the union, I have absolutely no voice. Here's my money, do what you wish, and I'm just a slave to whatever you want.
I'm a slave for you.
There you go.
Thank you.
You want a snake?
Oh, God, you're getting me in trouble. No boas. So maybe John's onto something, right? Maybe the issue is that when you vote with tax money, and if government spends your money in a way you don't like, you're screwed. Alicia, what do you think? Is paying money the same thing as being compelled to speak? Is that the same act?
I would say it's not the same act.
Yeah.
It's similar, but it's not the same. The issue here was that he didn't have a choice. He did not have the choice to not pay. he only paid.
So say that again?
50%. The issue here is he really did not have a choice to not pay.
Okay.
He did not pay the full 100%, but it was still 80% taken from his check.
Mm-hmm.
So he could elect to be a non-member, but he still had to pay.
Yeah, so wait, you want to add something?
Wasn't, and also, like, with that, the fact that non-members, even though they had to pay, they couldn't vote on anything. So they couldn't add to their voice at all.
Yeah, right. So that's an important point Whit raised. If you decided to not be a member, you're basically getting this 80% taken out, and you got no say in how the money was being articulated. You couldn't vote at the union meetings and stuff. So I think this question's actually difficult. I didn't used to, but I sort of go back and forth, right? We all know that the government can't compel you to speak, right? They can't make you salute the flag. They can't make you endorse a candidate. But they make you pay money all the time for different things. So is making someone pay money forcing them to engage in speech, right? I suppose you could say, well, if I am paying dues here and the union pays money for candidate X and I don't like a candidate X, then you're being associated. But you can say, look, I'm paying this money, but I don't agree with these people. They're taking against my will. Is that even associating? Like, is that you actually being forced to associate under protest, right? Isn't by virtue of the fact that you're not joining the union a signal of the protest that you don't want to be associated with their causes? Or how is this different than just a general tax the state can assess to fund lots of crap you disagree with? Yeah, Carla.
Isn't when the government taxes people and spends that money, isn't it supposed to be viewpoint neutral? Whereas
Nope. No, I mean, look, when you're the government and you're spending money, you can pick and choose who you want to spend it on, right? If the state of Illinois wants to subsidize unions, they can do that. And if the state of Texas wants to subsidize gun clubs, they can do that, right? There's no required neutrality in the government spending money. Yeah,
Isn't
Tracy.
kind of an example of this in Houston, like the Prop B stuff that's going on right now?
Remind me what Prop B is?
That was the firefighter.
Yeah. Right, so I mean, look, if the city of Houston wants to give a sweet deal to the cops, not to the firefighters, then they can do that, I think. Yeah.
This may be a stretch, but in the very first sentence of the Constitution, to form a more perfect union, like, we're paying taxes and we're all a part of, those citizens are a part of the union. You really don't, if you don't want to pay taxes in the United States anymore, you remove yourself from the union. So there, since they remove themselves from the union.
Declare independence, yeah.
Right, or move to another country or something of that nature. So if you move yourself from the union in this context, why should you have to pay those taxes? Right, like.
I mean, but we generally, look, I'll give you an example, right? There are various federal taxes that benefit, let's say, corn farmers, right? Ethanol taxes. Subsidies to farmers. They're not subsidies to law professors, right? There are no subsidies to attorneys. There are subsidies to corn farmers. The government is not neutral in how they allocate tax funds, right? You will realize this very soon when you become more money earning. But money spent in a non-general welfare way. John?
How do you reconcile this with Obamacare? Because they seem almost like the exact same identical argument.
Making whoa, no. Okay, so
is it a tax or a penalty? Seems like it's both.
So I mean, the Affordable Care Act was if you're not in commerce, can they make you buy a commercial product? Here, a state, not the federal government, a state does have the power to make you pay money if you're working. So I don't think there's an Obamacare analogy.
It seems generally the same thing.
Look, I make everything about Obamacare. This is not Obamacare. this ain't it. For once. God. I've had enough John Roberts for today. Come on, no more. He will disappoint me at midnight tonight, I think, like a pumpkin. Just watch. Okay. Maybe not. Maybe he'll surprise me. Probably not. All right, so what? Oh God, no. By the way, so the guy in Staten Island who shot the mob boss, he lives like maybe a 15-minute walk from where I grew up. So of course, Staten Island, right? They interviewed the guy at the deli where he used to go, and it's right near my house. God bless Staten Island. Okay. And the reason I mention that is, at his arraignment hearing, he wrote Q on his palm of his hand. It's reference to QAnon. If you don't know what that is, don't ask me. Don't Google it either. Don't tell them.
Even they don't know what it is, right?
No, you gave me this about Ginsburg 2 weeks ago.
What, me?
Yes, you.
What, that she's part of Q?
No, that she's dead.
Oh, yeah, speaking of Ginsburg, it's been the whole time. I think she's like the same shit from Jurassic Park.
What?
She's just complete CGI at this point. I don't know.
Oh my gosh.
So she's basically Jar Jar Binks, right?
I don't know. I don't know how she's still doing it. And I love her. I love her.
But she's gotta have some amazing health insurance, like, just put it that way.
Stop. I can't. Stop. Stop. Back to law. I can't. This is insane. Oh, my God. She's Jurassic Park. Okay, thank you. All right, so again, I don't think the argument in Janus is lock solid. I think it's probably right. I think Abood was premised on the idea that paying money was a form of compelled speech, but as a matter of first principles, I go back and forth. I think it's a hard question. But let's talk about stare decisis a little bit. If you have me for common law, we discussed a case called Planned Parenthood versus Casey. This was an abortion decision that discussed whether Roe v. Wade should be overruled. And the decision did a lot of things, but about a third of the case was about stare decisis, about why it was so important to stand by Roe, even though the court basically modified Roe in significant ways. And here I think the biggest debate between Alito and the majority and Kagan in dissent wasn't really even about the First Amendment. I think Kagan more or less agreed that the line drawn in Abood was pretty stupid. But they really fought over precedent, right? Dyer, I think you're next. What's the major divide between Kagan and Alito on stare decisis? Alito is the majority, Kagan was the dissent.
One was basically saying that the stare decisis has no effect if the reasoning behind it was wrong. You should be able to overturn it, no matter. It shouldn't be given any definition.
What about reliance, right? So Kagan says, well, across the country in 20-something states, they adopted these sorts of contracts. Negotiations were made based on this understanding, right? What's Alito's response to that one? It's a very peculiar response. I'd never seen anything quite like this before.
I don't really remember.
You know what I'm talking about? Yeah, Kyle?
Basically, it was 6 years coming, so
Yeah. Wasn't it a weird argument? Cameron, what do you think?
I thought so, and then
Yeah.
one of the things that tied in with, one of the, I think, smart things with Kagan's dissent was there was a lot of Scalia.
Oh, yeah. That was deliberate.
I'm sure it was.
Although Scalia would have totally voted to overrule Abood, so it's not even a close call. But yeah, look, yeah. So let me do Kyle and Cameron's points together, right? Alito's like this. He said, look, you should have seen the writing on the wall. We were just waiting until we had 5 votes, right? We were just waiting to overrule the case, and this has been a practice of the Roberts Court, right? A colleague of mine, Richard Ray at UCLA, writes about this, that the Roberts Court doesn't declare stuff unconstitutional right away. They give you a warning about it, right? So there was a case called Northwest Austin, which involved the Voting Rights Act. And the court said, well, we think the Voting Rights Act is probably unconstitutional, but we're not going to strike it down now. You better fix it. They didn't fix it. Come back a couple years later, Shelby County v. Holder. Okay, you guys didn't fix it. We're going to strike down the section whatever the Voting Rights Act. And I think the compelled speech cases are the same. Well, you had Harris versus Quinn, another case Knox versus SEIU. Okay, we think Abood's wrong, but we'll decide this case more narrowly. But just you wait. Putting you on warning. We're going to get you. And they got him. Now, I think this is an idiotic way to be a judge, right? This is just bizarre. Had Merrick Garland replaced Scalia, they've never gotten to the end game, right? It's like they're saying there's goal down the road, assuming the road's straight, but roads zig and zag. So it's only by virtue of Gorsuch replacing Scalia that they got to the 5 votes. So, but this is the Roberts Court's modus operandi. They hesitate striking things down right away, but it's like, look, don't act like you're surprised. We all knew this was coming. We all knew it was coming.
Isn't that though, like, it kind of gives them a leg to stand on that we don't practice judicial activism? Like, to allow you to fix this?
Does anyone actually believe that?
I mean, I would like to believe in it.
Again, so let me take Andrew's question, right? I think it's a fair question. Andrew says, well, can't the Roberts Court say, look, we're being restrained here. Look, we're giving you a chance to fix it yourself. Let democracy fix it. No one actually believes that, though, right? I think that's John Roberts, I think, does believe in it. It's delusional, right? It's based on this like what's the right word? Like the Sesame Street vision or Schoolhouse Rock vision of how the world works. What word?
Utopian.
Yeah, it's like utopian, right? It's like, oh, wow, this is wonderful, right? A bill that passed both houses of Congress had like a 400 vote majority in the House will just be changed all of a sudden. They're not going to do that. And in 20 very heavily union states that have renegotiated all their contracts to avoid these sorts of compelled speech provisions, they're not going to do that. So I mean, look, I think on paper maybe it looks like, oh yeah, we're giving them a chance, but in reality,
It's kind of one of those things you want to stand by your principles. Like I'm gonna follow the rules that I want to, the rules that I've always followed and believed to be true. But
yeah.
I mean, it's like, hey, I gave you a chance to do the right.
Well, let me put it this way, though, right? Is it a job of a judge to give government a chance to strike things down, or is it to do whatever the Constitution says and be damned? Alito says the Constitution doesn't permit even an additional day of free speech being violated, so we wait like 6 years?
I mean, that's kind of one of the things, like, I don't know, maybe I'm just being too optimistic about it.
Sure, that's a fair point.
That was my main issue with, the Obamacare case is how he kind of took it in his own hands to make the argument that no one brought up, about it being a tax, and so.
Well, not exactly. Did you have me for Conley or property? Oh God, watch my no. So the taxing issue was briefed. But if you did have me for property, we did a case called the Splunking Explorers, and that you might remember, right? Where one of the judges was, it's a fake case, but one of the judges was eager to sort of negotiate with the political process. Nathan, and then someone else.
I find it kind of hard to, take Supreme Court justices seriously whenever they harp on stare decisis, because they only do it when it serves their own purpose.
Yeah. I mean, I'll just jump to one part of Kagan's dissent, and I put a big flag. We'll see if anyone else knows my flag was. So Kagan wrote towards the end of her dissent, the court has overruled Abood because it wanted to. Because, that is, it wanted to pick the winning side in what should be, and until now has been an energetic policy debate. What did Josh write in his notes next to that line? Just anyone wants to guess how I think. Better than any sort of questionnaire, right? What did I write there, right? That the court picked the winning side in what should have been an energetic policy debate.
Well, it's like with her, it's Scalia of Obergefell.
Bingo. Actually, Roberts of Obergefell, but it's very close.
Sorry.
Yeah, but you're very close. Roberts and Obergefell have the same line. He said that the court picked a side in a debate. It's almost verbatim what Roberts wrote. Any majority member in Obergefell, I think, is stopped from raising stare decisis ever again. You overruled millennia of laws, the 5 votes. So again, that is the exact argument that Kagan raised that Roberts raised in the same-sex marriage case. It's the exact same argument. Let the political process work itself out. Abood's 25 years old. The marriage laws were a heck of a lot older. They were much older, right? Anyway, but I think Nathan, I think your point's well taken. That stare decisis is usually the party usually calling for stare decisis is the one who wants to keep the old rule in effect, and there's not much more to it. Justice Alito, a couple years ago, what was I want to get the quote correct. He didn't say this publicly, but I tweeted it. And then the New York Times quoted my tweet.
The failing New York Times?
No, they're doing well. So a couple years ago, Alito, here it is. So I was at a conference where Alito was speaking. I wrote this down, and then the Times quoted my blog post. He said, stare decisis, okay, as I'm sure all of the lawyers in this room know, stare decisis is a Latin phrase. It means to leave things decided when it suits our purposes. He offered an example. Stare decisis is like wine. If it's really new, you don't want to drink it. It has to age for a while. If it's really old, it's very valuable, or possibly turn to vinegar. There's this magical period in between. It's not difficult for judges to make the stare decisis inquiry come out however the judge wants it to come out. I almost have an idea, and maybe this is stupid, but give it a shelf life. Say a precedent's good for 10 years, and then we'll deal with it. Just 10 years, we'll see what happens. 8 years, 9 years, whatever the number is. We'll say, this precedent's good for 9 years, then we'll reconsider it. Because I think, as a practical matter, when a justice leaves the court, people stop caring about his precedents as much. I think Scalia might be the outlier. But I mean, the Kennedy precedents, my goodness, those are going to be hauled under the bus real quick. It's just they didn't matter. So I would just put a 10-year limit on it. Any precedent has to be reaffirmed every 10 years. And if it's not, it's overruled. Just be a little bit more, 5 years, 8 years, whatever the number is. Anyway, so I'll never be a judge. But I think it's a worthwhile idea. Just run a clock out. And if it's still good law, then they can reaffirm it. But don't pretend like getting rid of an old rule is bad. I don't know. All right, anything else on Janus? It's a significant case, I think, more for the stare decisis in the First Amendment. I think I'll put a much shorter version in the book. So sorry it was so long. John?
Did Scalia, was he around to even hear it, or was he already dead?
I heard it from the great beyond.
Oh, so he was already dead.
No, he was gone. He died before Janus. So the way it works at the court is the case was argued, Friedrichs was argued, the opinion was assigned. Alito, I think, had it, and then Scalia died, and because he wasn't there when the opinion was announced, his vote didn't count. Right?
No,
Even
he
though,
at least had his documents and his notes to read.
oh, we know he joined it, right? I mean, we don't know publicly, but we can be pretty certain he joined it. You might remember the legal tender case, which is somewhat of an obscure case, which was about whether Congress can make people accept paper money. And in that decision, one of the justices died before the opinion was released. And Chief Justice Chase noted, well, this guy's dead, but he voted with us, right? The court doesn't do that anymore, right? If you're dead, you're dead. In fact, there was the Ninth Circuit has this very strange practice, not anymore, they used to, where if a judge joined an opinion and then died before the opinion was issued, they would still release his opinion as a binding vote. And then the Supreme Court basically said, nope, you have life tenure, not beyond, and you can't cast an opinion from beyond the grave, which I think is a good rule. Okay. What else? Anything else in Janus?
I have a question.
Yes, Alicia.
So, work for the federal government.
Mhm.
I'm not allowed to speak out about certain things. So does this overrule that?
Okay, so how many of you are government employees? Anyone else? A couple of you. Roxy? No? Okay. So there's a case called Pickering, which was cited in your reading. And this is what's often called the government speech doctrine. So let's say that you work for the district attorney or something. You write an op-ed in a newspaper critical of the DA, and then surprise, surprise, you get fired. You have a right to opine on certain matters of public concern, but your boss also has a right to discipline you for things within a certain sphere. It's a very mushy doctrine, but as a public employee, your speech rights are limited. Now, for example, you work for the courts, I think? Are you allowed to have a bumper sticker in your car
That I don't
for a
know.
political candidate?
But I
Probably
know that
not.
when we were doing the shutdown, we were not allowed to use we're not allowed to use social media anyway, technically, but
Really?
yeah.
Judges are all on Twitter, by the way. They all know.
Yeah.
They all know. I think Kagan follows me, but I can't prove it. I don't know. What do I know?
Well, she's a higher up.
Yeah.
You know.
No, but it's law clerks, for example, they can't have, she said she reads my blog, so I suspect she does my Twitter also. But law clerks, for example, can't have like political bumper stickers. So they do have limited speech rights. Did you want to add something?
Oh, no, I was just going to say, with that, I applied for additional clerkship, got it, and that was one of the things they told me.
Yeah, that's in the training usually. Where are you clerking?
The 295th.
Good for you, yeah. Good for you. Yeah.
Does that work with like banks, even though, so I work in the private sector and I have a lot of banks that say you can't say certain things.
Yep.
You can't do certain things, you can't.
Well, there's no First Amendment. Right.
They're very, very careful on what their employees
Right.
to other candidates.
When a private employer restricts employee speech, there's no First Amendment issue. Like I'll actually give you a funny story. When I was a summer associate, my second year of law school, one of the, that's why I became a lawyer. one of the partners, one of the attorneys said, I want you to write a memo. I was like, okay, what? It's like, well, we represent an airline, and the airline's cracking down on what their employees can post on social media. This was back in 2009. He said, I want you to write the First Amendment implications of the airline telling their employees that they can't post on social media. And I just took a step back. I was like, what? The First Amendment's like, it's a private airline? Yes. I was like, the First Amendment doesn't apply. And she just made this look like, and then it's about then I realized I couldn't be a law firm associate. It's just been very bad. I just had this oh my God moment. What are these people asking me to do? Was that?
I was gonna say, get paid easy money if you know the answer.
Oh man, they gave me a lot of money. The law firms pay way too much money, but they handcuff you. You get acculturated to it, and you can't get rid of it. So I never took it. I made more in 1 month as a summer associate than they would make like in 6 months regular. It was insane the amount of money they throw at you. Like,
Are they hiring?
the Mark Bennett position's unpaid, by the way, but you'll get a hell of a lot more value of what you're doing than those sorts of jobs. No, law firms are good, but just it wasn't for me. But yeah, I was like, First Amendment, like, no. And then she had no idea. Like the exact question Jessica asked, she was like, she's a partner. So now you know. Good job. You all know. And one day you'll be the smartest at the law firm. Yeah. Now, there are certain union agreements that prevent employers from restricting their employee speech. But that's a matter of labor law. Anyway, you guys now know. Okay? So any other questions on Janus? Okay, let's do the next case. The JCs. Anyone actually a JC member? I think I've ever met one. Anyone ever been to a JC meeting? Not JZ.
Wasn't Gacy, remember, like a high-ranking member?
John Wayne Gacy?
I think so.
I don't. Yeah?
Sorry,
Gacy the JC? Listens to JC? So JC is 1984. It's a Brennan case. This issue relates something we've studied maybe we didn't study it yet. We will. Which is the cake case, the Masterpiece Cake Shop case, right? The government enacts a law that says you're a place of public accommodation. You have to serve everyone. A gay couple walks into the bake shop and asks for a same-sex, wasn't a wedding cake, but a same-sex commitment ceremony cake. And the guy says, no, I have a First Amendment right. You can't compel me to make this cake. The state says, no, we're enforcing our discrimination law. The Supreme Court ducked the issue. They resolved the Masterpiece Cake Shop case based on the free exercise of religion, which we'll get to later this term. Did I assign Masterpiece Cake Shop? I think I did. No? Nah, it's not very important. I probably shouldn't. I think it's going to be an outlier. Okay. But this case is a little bit different, right? Here, you have a local chapter of this national organization, and this local chapter is ignoring their corporate charter. They want to admit women. And the national organization says, no, you can't admit women. So that gets a little funny, right? The posture that this case arose is a bit unusual. Noel, I think you're next. So give me the facts and JCs.
I'm not there.
Okay. Nathan?
So these, full disclosure, I'm not exactly sure what JCs is.
It's a civic organization, right? It's a group of, like Rotary. You guys know Rotary? Kind of like that. Yeah, like adult Boy Scouts. But these aren't as important today as they once were, but yeah, these civic groups used to be very important. Today, people just don't care. They sit on their phones all day, right? It's just not important. Yeah, Nathan.
So the local chapters, once they had their charters revoked by the national organization, they sued under a Minnesota discrimination statute, which is where the two chapters were. And they said that, by revoking our charters because we admit women, you're violating this anti-discrimination
Yeah.
statute.
So let's be very clear, right? The local group in St. Paul and Minneapolis, right, the Twin Cities, they wanted to admit women to full membership. Not just as associate, right, this halfway membership. They wanted to put women as full members. The national group said, we're going to revoke your charter, right? When you're an organization, you follow your bylaws, because corporations, right? You follow your bylaws. If your bylaws say X and you don't do X, that the national group can revoke your charter. That's how these corporations operate. At that point, the local group sued the national and said, you're in position of sanctions, violate local Minnesota law concerning public accommodations. And the local group sought an injunction, the national group then sought an injunction to block the Human Rights Commission. And they said that requiring them to accept women as regular members violated the rights of free speech and association. So it's a very strange case. Here, it wasn't that a woman tried to apply to the group and was denied and sued. That's what you would think the case would be, right? Instead, the group voluntarily admitted women as full members. The national tried to revoke their charter. And then the local tried to use state law to block the imposition of sanctions, as they can keep their charter. They can still be a chartered member, which lets them vote and do other sorts of things at the national group. So it's a very, it's a very strange fact pattern in which this case even arose. All right. So McKinney, what happens? Right. Walk me through the case.
So, facts were already laid out. They were admitting women under that state statute, and the court ended up holding that the freedom of association doesn't cover this type of gender-based discrimination because it's not placing a burden on the other members to express themselves or peacefully assemble by admitting these women.
Let's take it one step at a time, McKinney, right? One step at a time. Why, in this case, did the court find that there wasn't much of a burden? It was actually a very Brennan-esque, narrow, fact-based holding. Hold on, John? McKinney, then I'll go to you. Yeah.
I'm sorry, what was the question?
Tim. John, it's fine.
Because they already let the women in. And like
In what capacity?
As members, general members, they just had restricted rights. But what about the freedom of the contract? It's not like it was a hidden clause like, oh, whoops, you're already in, thanks for the money, you can't vote. They knew it when they volunteered to enter into that.
Gabe?
Yeah, wasn't it because he really didn't change the creed and like the ideology?
Exactly. Okay, so I think Gabe's right. Brennan says that based on how this organization is already structured, admitting women would not materially change how the organization functions. Says who? Says William Brennan, right? Let me just give a hypothetical, Gerald. Let me give the hypothetical for a minute, right? Let's say you had an organization that admitted no women, right? Just the Jay-Z's, right? There's no women allowed. Wasn't the Little Rascals the meat? Yeah, thank you, right? Yes, that was really good. Good job. So from the Little Rascals, right? You have the He-Man Women's Hater Club. Is that it? The He-Man Women Haters Club, right? Admits no women. Gerald, will that case come out differently?
Yeah, actually.
Okay. Yeah, why?
Well, because here, what you're doing is you're restricting the rights that someone has within the membership. There, you're just flat out excluding the people from membership, or a sort of.
But what if the club was content to say, Gerald, we're okay with women to do the sort of ancillary stuff, but the core, right, voting, we only want men to drive the direction of where this club goes. They can do other stuff. They can do volunteer. They can come to dinner. But we don't want them voting, right? Isn't that a different statement?
Isn't the freedom of association therefore can presuppose the freedom not to associate? So.
Yeah, Carla?
Wouldn't that essentially be saying that
women don't have the capacity to make a rational vote
Okay, and this is where I think Brennan, his point is actually strongest, right? Brennan says you're stereotyping, right? You're saying that because a woman is there, that she's not likely to vote in the same fashion as would a man. And that's based on a stereotype. Okay? Now, factually, he's right. The group is stereotyping that if you allow women to vote, they'll vote in a way that's adverse to men's interests. That's basically the point. That might be a stereotypical view, but is it one these people are not entitled to hold? Right? Let me just make this point a little bit differently. I'll give you an example, another case that's not in the book, maybe should be, but it's not in the book. A case Society versus Martinez, decided in 2010 or 11. And you have a group called the CLS, Christian Legal Society. And they have a charter that says a lot of things. And one of the charters says it's to be a member, or it's to be an officer, I can't remember. But to be a member, you have to believe in Christ. Okay, that makes sense, right? If you have a group called the Christian Legal Society, they want people who believe in Christ. And if you're an atheist, I think it stands to reason you might not want atheists voting in the direction of the CLS. It could even probably possible that the atheists take over the club, they have a majority membership, and revoke the charter and make it the Atheist Legal Society. I'm just making stuff up, right? But is it so irrational for a group to want people who are like-minded to constitute the membership of their group? Brennan, he's careful. He doesn't say that this stereotypical view is wrong. He doesn't say that, but he says, we don't know exactly how people vote. So the first part is they say that admitting women as full members will not change this organization much because they basically have almost full voting rights. So it won't be that big of a change. But it's a very narrow holding. It's a very fact-based holding. And I don't know that it necessarily forecloses Dale, which we'll get to in a couple of minutes. All right? So the first issue Brennan says is we find that admitting these women would not materially change the group. Kyle, what sort of deference is due to organizations if they say that making this change will alter our organization? Should the courts defer to those sorts of determination?
Generally, yes, unless the state has a compelling overriding interest.
Okay, and what's the compelling interest here?
To eliminate sexism, basically.
Yeah, to eliminate sex stereotypes and the like, okay? So generally, I think there's deference, but I think Kyle stated the Brennan opinion correctly. When you have a compelling interest in eradicating discrimination, and the court says that this interest here is compelling. Let me just take a side tangent. Jessica, is a private organization a public accommodation? In this case, why was the JCs, which is a private membership organization you have to apply for, considered a public accommodation?
Like given the nature of what their members were doing, like the reason why they were all joining together, that was public accommodation?
Generally, when I say public accommodation, what do you usually think of when I say a public accommodation?
Like inns and...
Yeah, like a restaurant, an inn, a railroad, right, a bus station. Why is a public group a public accommodation? Gabe?
Was it because let's say in a restaurant, everybody's admitted as far as like race?
Yeah.
In this group, it didn't matter what race you were, you just have to be 18 to 35. So
But didn't they scrutinize your character and didn't they do other things when they were admitting you?
you just have to be 18 to 35.
But couldn't a private group turn someone away? It could. Yeah, I think this is one of the study guide questions gets at this point. There's not much of a discussion of why, about why this place is a public accommodation. There just really isn't much of a discussion on that point. The New Jersey issue, too, in Dale doesn't really get into this either. But if you define public accommodation more narrowly, I think you eliminate a lot of these sort of free exercise, free association issues, right? Let's take a church, right? Churches usually have open doors, right? Anyone can just walk in off the street. They don't check for your baptismal certificate, right? Synagogues don't check for circumcision, right? Anyone can come in, right? Sorry, I've used that line before. Is that a public accommodation? Because anyone can walk in. And if a house of worship becomes a public accommodation, are they then bound by all the rules of public accommodation? Do they have to admit everyone regardless of their religion? They have to maybe have men and women seated in the same place. Some houses of worship separate them. Anyway, so just keep in mind when you broadly define the scope of public accommodation laws, you have these sorts of conflicts. And I'll just have one other point. In most states, discrimination laws don't apply to all businesses. They usually have a threshold. If you have 10 employees, if you have 5 employees, if you have 20 employees, whatever the threshold is, right? And that's not because we want small businesses to discriminate. It's not as important for small businesses. Generally, they're more closely kept. Maybe they have certain beliefs. Maybe they don't have enough staff to treat everyone. I don't know. I think almost all these cases, like Masterpiece, would be eliminated if you put a threshold. It's only discrimination for more than 5 employees, 10 employees. Small businesses would just be excluded altogether. I have a paper on this. I'm still tinkering with it, but I think it would eliminate a lot of these sorts of issues. But the JCs were big. There were hundreds of members. The JCs, I think, though, is not a public accommodation in any meaningful sense. It's a private group. They meet in private places. You have to become a member. It's not like a railroad.
But they're a civic group, and so they're out in the public.
But does that make it a public accommodation that they're out in the public doing good for the society?
I think there's a strong policy argument for that.
Okay. Anyone else want to add something? Yeah, Brittany.
So does that mean like the Red Cross a public accommodation because they're not doing good, but they're a private business? And the GCs are funded privately, so.
I think Alicia's getting at an important point, right? We would want public accommodation laws to apply broadly so that if anyone walks into a group, they don't feel excluded. But when you apply public accommodation laws very broadly, I'm sorry? You sweep in some First Amendment problems that could be otherwise addressed. In other words, I think the JC case would have been addressed much more easily if they said this is not a public accommodation, be done with it, rather than scrutinizing how much of a burden is there on it. Because look, I mean, think about it. If this local organization really disagrees with the national group this much, they can just splinter off. You see this with churches, and you might see this with the Methodist Church soon, right? A lot of churches that started recognizing same-sex marriage splintered off, and they basically went different ways because they disagree with the new charter. And if groups don't like their national policies, they can make their own local group, right? The court shouldn't force the national to accept the local policy. But anyway, this is a weird case. It just arose in a very unique context. Okay. Let's see. Anything else on JCs?
I just wanted to make a
Please.
comment about your paper that you're writing
Oh, yeah.
about the small businesses, and there must be a threshold. I don't know that that's your position, but regardless of what the threshold is, the injury is still the same.
No, it is. Yeah. I'm not taking a position if it's right or wrong. Mine was actually a survey. I looked, I think, at all 50 states. I don't have it in front of me of the various states, and almost all states had a threshold. Even the Federal Civil Rights Act, I think it's 25. I might be blanking on the number. And even fair housing laws, where you can discriminate in housing if you have fewer than, I think, X number of units. And I don't think that's a recognition that small-time discrimination is okay, but I think it suggests that the interest might not be as compelling when the employer is smaller.
I don't know. The injury's the same. I mean, whether you're one person or 25 people up there, if you harm me, I'm still harmed. The injury's the same.
Thank you. Yeah.
Don't you subject that? I mean, it's not like there wasn't a million other organizations just for women at that time either. It's not like I can't go sue the Girl Scouts and be mad. I eat a ton of their cookies. but I can't be a member and then force them to hide behind a state law.
Well, I mean, that's a perfect segue to Dale, though, isn't it?
Of a 501c, instead of going through the right channels and letting them do it on their own, you forced it into them because of two, like, rejecting people. Wasn't it like 2% of all the population were even women?
I think this case was really, it was 1984, and at that time it was all about women entering the workforce and being empowered, and this was kind of a vehicle for court to put their stamp on it and say, that's just my opinion, and to say, up with women. ERA.
Did the JCs admit women nationwide after this? I don't think they did. I want to check that. I suspect the answer is no. I suspect this ruling was pretty narrow to the facts from which it arose. Because I don't think that subsequent to this, groups in other states were required to admit women. It was just a very unique position where the local group wanted to, and whether their charter could be revoked. It was a very narrow holding. And I think the narrowness of that holding leads to the next case, which is Boy Scouts against Dale, which I think has a bit of a broader approach. Jesse, you want to give me the facts in Boy Scouts versus Dale, please?
So this was a boy who was in Boy Scouts, and they kicked him out. He was a former Eagle Scout because I believe there was an article in a newspaper in which he kind of voiced his opinion because he was gay, he was actively he was open about it, and they didn't agree with that, so he wasn't allowed to be I can't remember the term, the counselor or like the
Scoutmaster, yeah.
There it is, because of it. So he sued because he wanted to be a part of the organization.
What was the basis of his suit? What was he relying on?
Expressive association?
No, I mean, what law was he invoking? Yeah, that's a constitutional right, but what law was he invoking?
The implicit right to engage in activities.
No. The Boy Scouts defend in the First Amendment. What law was Dale relying on? So the answer is very easy. You're working too hard. The state discrimination law, right? The New Jersey discrimination law prohibited discrimination based on sexual orientation, right? The Boy Scouts then said that the First Amendment of federal law trumps or preempts this state policy. Now, let's just place this back in time. This was 2000. Lawrence v. Texas had not yet been decided. That was 2003. Bowers against Hardwick, right? That was the case that said the state could criminalize sodomy. Was still good law. The court had decided Romer v. Evans, which set aside the Colorado Amendment 2 involving gay rights, and Congress had enacted 96 the Defense of Marriage Act. I think in 2000, one or two states may have had civil partnerships for gay couples, but no state had gay marriage at this point. That came several years afterwards. This case was decided at almost like an inflection point, because within a couple years you have Lawrence, and once you get to Lawrence, it's sort of off to the races to Obergefell. But this was at a specific pinpoint in time where public perception of gay rights wasn't what it was at Lawrence, and certainly wasn't what it was today. Gabe?
Yeah, like it's almost like the last one case, they can kind of like chill their back and then before.
Yeah. I mean, look, Justice Kennedy was in the majority here. He didn't write a separate concurrence or anything. I think this was like the last case where Justice Kennedy, I guess Massacre's Cake Shop, but between Lawrence and Windsor and Obergefell, he ran the table. So this was a flashpoint, and just the way Justice Rehnquist writes about this, he said he was an avowed homosexual and gay rights activist, and that sort of language you wouldn't even think of appearing in an opinion text, even like the the Roberts, Dissenting, and Bergefell, an avowed homosexual. Like, what the hell does that mean? I guess it means open, out of the closet, I suppose. I think that's what it means, avowed. But it was written at a very unique point of time. And because of the way Justice Brennan wrote the Jaycees decision, Rehnquist followed a very peculiar path, right? In Jaycees, the question was, would forcing them to admit women change their message or change their approach, right? So in Dale, Rehnquist had to adopt a similar question, right? Would forcing them to admit a gay scoutmaster go against their values or change the message they're trying to convey? Gabe?
Yeah, but he can't address that because he wasn't even speaking to the troops about homosexuality. He wasn't even like putting signs or even like teaching them what to start. So I think he kind of dropped the ball right there.
Okay, so this is an important point, right? How do you reconcile Jaycees with Dale? I think there's one crude way of doing it. They were decided 15 years apart with a more conservative court, right? Brennan was replaced by, well, Souter, but you have 5 more conservative members. There's also the issue, to Alicia's point before, the perception towards women, I think, were perhaps quite different in 1984 than perception towards gay rights were in 2000. Nathan?
Well, I mean, not saying that I agree with this ruling, but I mean, another contrast you can draw is that the Boy Scouts of America it's not meant for the adult members. It's meant for the boy members, so they're excluding right? Because it's meant for like leadership among youths, not necessarily the adults joining.
Mm-hmm. Well, let's walk through this one step at a time, right? In Jaycees, women were admitted partially as these associate members, but they could be, they could be in the club. Did the Boy Scouts policies, did their charter actually exclude gay members? No. What was the argument that the Boy Scouts raised that it did? And this is a little bit of a fuzzy argument.
So in court, the Scouts argued that their code of being morally straight and clean was the foundation
God, yeah.
for saying that homosexuality was somehow correlated with not being morally straight and clean. And the opinion wasn't clear on, in my view, how they expressed this idea, but they did just kind of say that's the correlation they were trying to.
So this goes back to the question I put to Kyle, I think, a few minutes ago, with what level of deference should the Boy Scouts get in defining their own code or interpreting their own code?
So the court said that there was a strict scrutiny approach towards what they had a compelling interest in furthering what they believed.
No, I'm not going to scrutiny, but to what extent should the court defer when the Boy Scouts say that homosexuality is prohibited by our code? How much scrutiny should the court apply to that determination?
Didn't he say considerable deference?
What? No scrutiny, not no deference. So all deference, right? So I think this is the question, right? Can a party set their position in litigation documents, right? Because the Boy Scouts have been around for 100 years. They had this old code. They didn't specify with a lot of, clarity what is and is not prohibited. But an agency comes to the court and says, Your Honor, it's our position that our code prohibits. And the dissent goes, well, it's not in the code, so we don't have to defer. What deference is due? And I think one of the study guide questions flags this. But think of Grutter and Gratz, right? The affirmative action cases where the universities were given a lot of deference concerning how diversity can improve their education, even if they weren't very precise about it. So, Colby, If the Boy Scouts come to court and say that admitting this gay Scoutmaster would impact our message, what do we do with that argument? I mean, it's not an easy question. I think the majority and dissent have arguments on both sides. But I mean, what do you do if the organization says, if you make us admit this member, it'll change the message we convey? We're trying to convey a certain message, and we can't.
You have to take the organization on its face, because if the court does not, then anybody can bring a suit saying that these policies are against me.
But the charter doesn't say anything about gays. It says clean and whatever, straight, moral, whatever the word is.
Morally straight,
clean. So Joseph, let me ask you another question. What if after this case, the Boy Scouts amended their charter and said, we exclude gays, period? Would that change the outcome of the case?
I don't think it would change this outcome of the case. It'd have to be before.
No, but you know what I'm saying, right? Let's just say, you're in the trial court, right? And the judge issues an injunction saying, admit the gay Scoutmaster because your policy is not clear enough. And then they go back, they re-amend their code, they, aha, no gays allowed. Says it.
I think if you assess the organization as kind of controlled more on the private sector side of things, then you have to accept that argument.
Yeah, so if this case could have been resolved by the Boy Scouts just amending their code, in other words, instead of stating the position in their briefs, they just pass an amendment to the charter, which can be done at an annual meeting through the deliberative process. So the deference question I think is important, but I don't think it ultimately makes much of a difference, right? Whether the Boy Scouts assert the position in a brief or in an amendment to their corporate charter, I think it doesn't really make a difference. The more important question, though, is why is admitting gay Scoutmasters going to harm their image? And I'll just say this point, which you're probably aware of. There's a long-standing stereotype, and it's an awful one, that associates homosexuality with pedophilia. I can't say any more bluntly. There was a fear that admitting gay Scoutmasters would lead to abusing children. Now, there are plenty of straight Scoutmasters that engage in awful acts. So this stereotype is unfortunate. And I don't think the court wanted to say this, but it was lurking, I think, in the background. And there was also a perception that if young children were exposed to gay men, that maybe they'll become gay also. And this you don't hear this as much today, but this is how people argue. Gabe?
So on the dissent, it was noted that the parents from the little kids knew that he was gay.
Yeah.
But my question is, from the opinion, what if it wasn't a co-president from like the organization he was part of? Would they because one of their argument was, well, because he's one of the activists for the gay community, because he's a co-president. He didn't have the title. What if it was just he wasn't an activist?
I suspect there were a lot of gay Scoutmasters that no one had much objection to, but this guy was outspoken, and they excluded him for that reason. Kyle, your hand was up a minute ago.
Yeah, two things. Like, first of all, Rehnquist is also the one that wrote Bowers versus Hardwick, right?
Rehnquist was in the majority in Bowers, as was O'Connor.
But that was his opinion.
No, Justice White wrote Bowers.
Sure? Okay.
Yeah.
Anyway, so then going on to my next comments, to me it seems that being gay and out of the closet, if their argument is that they're going to sneak up and rape the little boys, right? Then you would want them to be out of the closet as opposed to in the closet.
Yeah, you find them.
You can
Yeah.
flag them that way, right?
I suppose. Yeah. 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 No, I see your point. So the issue is this, right? Would admitting these people change the Boy Scouts' message, right? They can't come to court and say we're afraid these people will molest children because it was an insane argument. But what they had to argue is that by having these people in our club, it'll change how we view morality. And even though the morality wasn't defined with any precision, the court says we'll defer to how they define morality. And therefore, even though the JC's case was very narrow and fact-bound, this case then turns out in the opposite direction because of the narrow way the case is structured. There are expressive associational rights. Okay? During the time spent with the youth members, The Scoutmasters inculcate them with the Boy Scouts' values. An association that seeks to transmit such values engages in expressive activity. And their fear is, by virtue of the fact that the Scoutmaster is there, he will then inculcate them with different values. Even if I suppose they tell him, don't talk about being gay, don't talk about stuff, I think his mere presence, they argue, will be objecting to it. I suppose they can say, I guess you could have a situation where if you talk about sex, we'll fire you. I mean, maybe that could be a policy short of excluding the guy altogether, but they maybe didn't want to risk it, that it could, be inferred otherwise. And the court says, would Dale's presence burden their desire not to promote homosexual conduct? And they say we must also give deference to association's views of what would impair its expressions. And they cite this other case, Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston. This case involved a parade in Boston, where, as the name suggests, a gay group wanted to march. If I remember correctly, the parade organizer said you can march, but you can't have a sign being held that promotes gay rights, because that is contrary to our message. And Hurley ruled in favor of the parade organizers. Okay. Ultimately, the court held that New Jersey's accommodations law runs afoul of expressive association. There's a compelling interest here. They don't say about sexual orientation, but there's a compelling interest. And the First Amendment here trumps the accommodations law. Okay. Questions in the majority? Questions in the majority? Evan, you want to walk me through Justice Stevens' dissent?
First, basically, kind of starts off and says
Oops.
that there is a right of association for expressive purposes, but essentially what he just said is that, while there is that right, it's not absolute, and the state here basically meets a strict scrutiny test, and they meet the standard where they have a compelling interest, it's not related to the suppression of speech, and it's in the least restrictive means possible. He goes through this, he shows it by several ways. The first is, of course, would it really seriously burden the Boy Scouts? He says, not really.
So he hasn't deferred to the Boy Scouts' determination, does he?
No, he doesn't.
No, he doesn't. Sorry.
He doesn't understand. He kind of says it's insane that the courts say, okay, we have to believe anything they give us because it's a factual matter, and as a matter of fact, or the record or the evidence doesn't show anything that says that homosexuality goes against their morals.
Do you think Stevens would have come out differently in my hypothetical, where the code said explicitly we don't accept gays and lesbians? Do you think Stevens would come out differently?
I don't think so.
Nah. Which is why I don't find this entire line of argument very compelling. I think it's the issue of deference. If this case could have been solved by amending the corporate charter, then they would have amended the corporate charter. It's a lot cheaper than going to the Supreme Court to litigate, right? You can amend the charter at an annual meeting in about 5 minutes. And at least in 2000, it would have been easy. Subsequently, the Boy Scouts started admitting gay troops, gay Scoutmasters. They started admitting transgender boys, and now they admit girls. In fact, there are schisms within the Boy Scouts. I think Utah and otherwise want to make their own Scouts, which doesn't have those policies. So the political process worked its way, what Dale couldn't do.
Funny about that, recently, I think now the Girl Scouts are suing the Boy Scouts.
They're mad, yeah. Yeah, the Girl Scouts are angry that the Boy Scouts are admitting girls because there's competition. I don't know. I was anyone ever a Scout? I can't even tie my shoes. I forget it. Mostly joking.
Was there ever any talk of Breyer writing this opinion or him recusing himself?
Why?
He is an Eagle Scout.
Breyer? Was he an Eagle Scout? I did not know that. Huh.
Are your shoes tied?
Should I try these slip-ons? So I have to tie them. Was Breyer an Eagle Scout? I will look into that. I don't know. This is actually one of my pastimes, looking into why justice is recused. I don't know. I'm gonna look into that. I have no idea. I never thought of that before. Breyer was an Eagle Scout. Was he still a Scout at the time Are you an Eagle Scout for life? How does that work? So you can't like.
You're not a Boy Scout for life, but you're a Eagle Scout.
Breyer attained the rank of Eagle Scout at 12. Is that young?
Yeah, it's usually 14 or 16 to make Eagle Scout.
I think the rules might have been a little different.
Breyer was given an award. Wow. He was Distinguished Boy Scout in 2007. I didn't know that. I will look into why he didn't recuse. He should have recused. I don't know why he didn't recuse. It's a good question. I'll ask some people who followed this issue back then. I wasn't paying attention in 2000, but I will ask around. It's actually one of my pastimes to find out why given justice recused. I pay very close attention to these things. Okay. Where am I? Okay, so let's summarize Dale a little bit. The court, I think, applies the JC's framework, and unlike where the JC's admitted women as half membership, it wasn't that big of a deal to give them full membership. I think here Rehnquist said we have to defer to their own definition of morality, and if they tell us that admitting the gay scoutmaster will affect their message, then that's enough, and that the First Amendment then trumps the non-discrimination law. Okay, this argument doesn't apply to the cake shop case because, again, I think there you have what is really a public accommodation, a bakery. Rather here, I think a private organization. So again, if you narrow the scope of public accommodation, these sorts of issues won't arise. But by narrowing the scope of public accommodation, you are effectively tolerating, for lack of a better word, the injury, discrimination in different facets of our polity. Yeah, JC.
Flip side of that though, smaller the organization, then if it's somebody who obviously doesn't want you there, why would you want to be there in the first place?
What a good question. Oh, John, yeah, you want to answer?
Under reliance, I mean, he put in a whole lot of years and money in his own life into this, so why should he all of a sudden be thrown out over an ambiguous clause in a social contract?
That's like the Boy Scout thing, where I'm saying like in a small group, like 10 people, like, oh, they won't let me join their whatever club. Well,
So let me address JC's question, not JC's but JC's question. Why would someone want to be a member of a group that doesn't want them? Or to use a more recent example, why would someone go get a wedding cake from a baker who doesn't want them to get married?
Test case.
Okay, yeah. So some of them are test cases, and people do go into a shop to get sued, and that's why they go. They want to get turned away. But I think for other people, it stands for a principle. If the law guarantees access to these public accommodations, then I want the law to benefit not just me, but everyone else. So some of them are litigious, I don't doubt that. But I think for people, the principle matters. They don't like the fact that there's exclusion. So again, a lot of this turns on what exactly is and is not a public accommodation. New Jersey reads their statute very broadly to even go to a group like the Boy Scouts. Yeah, what? Oh, what a good question. I think Randy and I had the same discussion. Post Obergefell, I mean this, and I don't have an answer for you, but post Obergefell, can the court defer to this sort of determination that allowing gay people to be around children is risks corrupting them? And when Obergefell expressly said this is protected by the Constitution, I don't know if the sort of deference afforded in this case survives post Obergefell. I think it's actually a very tough question. I don't know. I was thinking about this exact issue.
I wanted to follow up because you kind of noted this too, and some of the reasoning the court dedicated to the deferring to the Boy Scouts was if you force them to have homosexual members, it would force them to essentially say they accept this lifestyle. But I mean, even in the sense of religious freedom, if they didn't want to, espouse the beliefs of Islam, would they be allowed to not allow Muslim members into their, group just because let person in? You know what I mean? Like, does that?
Well, again, let me use the Christian Legal Society example, right? let's say a group has a tenet, a charter that says to be a member of this group you have to believe in Christ. And we don't want non-Christian believers in our group because it will diminish our message, make it harder for us to pray and do other sorts of things. Can a club do that? And the Supreme Court decided on a very bizarre ground that I don't like to rely on because it was a university thing, but just as a hypothetical matter. Can a group of Christians that says we are Christians, it's not a church, but just a group of Christians who do legal work, say we want to exclude people who don't believe in Christ? That's the facts.
If the Christian legal society is solely, like, their sole purpose is to further Christian beliefs, then maybe.
But you have a public accommodations law saying you can't exclude based on religion. Or they say we don't want to have atheists around our kids because they might teach our kids about atheism, and we don't want that. Similar to the Scout argument. These are legit questions, and I'll wrap up. We are almost done, but I'll wrap up with a slightly different hypothetical. I raised this post to Bergefell, but what if a city gives tax exemptions, right, to churches, right? If you're a church, you don't pay property tax, which is usually the case in most cities. And the city says, okay, that's nice. We will only give you this tax exemption if you comply with our public accommodation law, which means you can't exclude gay members from your parish, or you can't separate men and women. And we're not forcing you to do it, but just withhold a tax exemption, which you're not obligated to have. These issues bleed into the free exercise. I'm glad Whit brought up the religious issue, but it's not only about morality. When you substitute the word morality for religion, the argument gets a little bit more juicy because you have free exercise issues. Anyone else want to chime in? Yeah.
The difference between the argument for the Christian Legal Society versus the Boy Scouts of America would be different if they were like the straight men of America. The Christian Legal Society specifically there, let's say about purpose, is to further or like, I don't know, foster Christian belief, right? Whereas the Boy Scouts...
But use my hypothetical. What if they amended their charter and say, we believe in morality and heterosexual marriage. We do not believe in homosexual relations. Boy Scouts. Yeah, they amended their charter along the lines I suggested.
They believe in it.
That's their charter. Do you question whether the charter is an accurate reflection of their beliefs?
If you want to be a homophobic, racist group or whatever, go for it.
Be public about it.
You'll be less popular, probably.
I don't know. I think the position they took in litigation, they could have gotten that same amendment made to their charter.
They should have.
Yeah.
That'd be better.
Andrew.
I was just gonna say, kind of with that, while I was an undergrad, I did a research into like fraternities and sororities and excluding, the opposite gender and everything. And what you saw in some cases on like smaller levels is that the organizations that didn't specifically like state like this fraternity is for men or this sorority is for women were losing their cases more.
So it actually matters what you put in your charter.
Yeah, so the ones that were losing it, saying like where they wanted to like exclude the woman who completed all the requirements for membership, they didn't specifically in their bylaws say it's for it's.
Value that. I think to pick up on Kyle's comment, be honest and be forthright about your exclusionary policy, and then you might win your court case. You might lose some members in the process. I think more likely the Boy Scouts, they wrote this code a long time ago and no one even considered this issue at all. And then the current leadership and sentiment was that this applies to gays and lesbians. Actually, it's gays. I don't think women were allowed at all.
The other argument is when this came out, I guess in most, at least southern jurisdictions, this would have been a crime. I guess what he's avowing, what he's declaring, right?
Was criminal, yeah.
Is that he has a preference for criminal activity, so I can see why.
Yeah, so maybe deference is warranted in that front. Yeah, did the court cite Bowers? I don't think they did. I don't recall.
Bowers anywhere in there.
But I guess Rehnquist could have said, well, this guy's advocating criminal activity, don't want him around kids. Right. Though in New Jersey, I don't think it was criminal, but I see your point. We start next week, my friends, in the free exercise of religion. I'll see you soon.